Order. Order. Tommy Sheppard to move the motion.
Thank you, Mr. Gates, and a pleasure, I think, for the first time to serve under your chairship. I'm delighted that I've had the opportunity to present this debate today, and I rise to move the motion that this House has considered human rights in the UK. Not for the first time, of course. We have, over the last few years, particularly since we began our BrExit journey, discussed the matter of human rights in the United Kingdom and what consequences there might be for that were this country to leave the European Union. And a number of colleagues, most notably my honourable and learned colleague, a member for Edinburgh South West, but others as well, have sought assurances from ministers that human rights protection in the United Kingdom would not be in any way diminished as a result of this process. And by and large, those assurances have been given. So why, therefore, is it appropriate to discuss this again today? Well, I think for three reasons. The first is that we've moved on in the Brexit process, and we now have a political declaration, or I should say a draft political declaration, which seeks to define the relationship that this country would want to have with the other 27 members of the European Union after, if indeed it does, leaves the European Union. And a number of us have noticed a slight change of language in that declaration when it comes to human rights. No longer is there a clear-cut commitment to support and embody into domestic legislation the European Convention on Human Rights, but in fact there is talk of respect for the framework which the ECHR provides. And whereas, of course, the other signatories to the political declaration, the other 27, quite clear in their commitment to the ECHR. So that suggests that there may be the possibility of some divergence between the United Kingdom and the other member states of the European Union in terms of their implementation of the ECHR. Also, of course, we have a situation where a government is led by someone who could hardly be described as being absolute in their commitment to the current human rights legislative framework in this country. When the current Prime Minister was Home Secretary, I would argue that she sought to undermine the Human Rights Act by suggesting that it was in some way soft on terrorists. Also, of course, it's worth noting that when she stood to be leader of the Conservative Party, she ruled out the possibility of repeal of the HRA, and not because of any matter of principle, but because there was not, in her words, a majority for it in Parliament. So one wonders what her position might be were the majority in Parliament to change. And finally, of course, we have a situation where the Conservative Party, the ruling party of government, was elected on a manifesto which pledged that there would be no repeal of the HRA whilst the Brexit process was underway. Now, who am I to guess whether the Brexit process is nearing its endgame or not, but it certainly looks likely that in 2019 it will get to its final stages, and we may or may not leave the European Union. So the question, therefore, comes about: what would the governing party's policy be on repeal of the HRA once the Brexit process has been completed, or at least got to a position of being implemented? So for all of these reasons, the central purpose of today's debate is to seek an assurance from the Minister and from the government that there will be no attempt to repeal, to undermine, to weaken or amend the provisions of the Human Rights Act of 1998. Now, I feel often when we discuss these matters of human rights that our discussions can get somewhat abstract and they can go over the heads of the ordinary man and women in the street. So I think it is important that we take this opportunity to state clearly why it is that human rights are so central to everything that we believe in, because in essence, human rights are an expression of what we mean by civilization. They define how individuals should react with one another. They confer respect and dignity upon the individual. And crucially, as well as setting standards for the type of behaviour we would expect from others, they set obligations on the type of behaviour we ought to give to others. So I would argue that the existence of human rights is absolutely central to our well-being as a healthy and dynamic society. People have suggested, and of course it's true, there are very, very few people ever think about their human rights, and they certainly don't need or feel the need to go to court in order to have them upheld. In fact, I doubt if other than a very tiny percentage of the population even know of anyone who has went to court on a human rights matter. But that in itself suggests how powerful and how useful the legislative framework actually is, because the central point of human rights legislation is not to allow people to seek redress if their rights are infringed. It is to protect them in the first place from people doing bad things to them. And the fact that there is so little court activity in this field, I think, is a vindication itself that the system is working. But of course, there are cases where the system doesn't work and where people feel the need to go and have their rights upheld. And I think it's interesting to refer to a few of these so that we understand and the public can understand just how central these matters actually are. Celia Peachey didn't think the Human Rights Act related to her at all. Her mother was killed at the hands of a violent partner, and she tried for years to get the police to do something about it, but couldn't persuade them to intervene. After her mother died, she was able to use the Human Rights Act in order to secure an inquest which returned a verdict of unlawful killing and criticised the police for the action that they had refused to take despite her making representations to them. The Driscolls were an elderly couple who depended on each other for care and support just to go about their daily lives. And when Mr. Driscoll was rehoused in a residential care home, his wife was not allowed to go and live with him. They used the Human Rights Act under the article of the right to a family life to argue that they should be rehoused together, and they won. And they were rehoused as a couple. In fact, not only was that of a benefit to them, but they set a precedent where it is now normal in these cases of considering residential care for the elderly to consider rehousing couples together. People will know of the case of Gary McKinnon, a young man with Asperger's who allegedly hacked into a NASA computer database and was wanted by the United States of America. They tried to extradite him to face charges which would have led to 60 years imprisonment had he been found guilty. He tried to resist that extradition, and in fact, to her credit, it was the then Home Secretary who in 2012 supported and said she was not going to allow him to be extradited because under the Human Rights Act, his rights would be breached were he extradited to stand trial in the US. And of course, the celebrated case of the black cab rapist, Stephen Warboys. There were two of his early victims in 2003 and 2007 who went to the police to complain what had happened to them, and their actions, their complaints were not investigated at that time. They used the Human Rights Act after the case came to prominence in order to get an inquiry into how the police had dealt with their complaints, and it was found that they had not done so correctly, and the police were reprimanded, and the victims received compensation as a result of their ability to use the Human Rights Act. And of course, many people will know of the continuing campaign by the families of those who died in the Hillsborough disaster to seek justice for their loved ones, and they have repeatedly used the Human Rights Act over the last 20 years in order to move their cases forward. And the final example I would give is the case of people trying to get redress against public authorities, particularly the case of health authorities, and in this instance, Mid Staffordshire Hospital. I don't want to go into any detail about the sad state of affairs in that institution, but suffice it to say that 119 families have now used the Human Rights Act in order to seek redress about the treatment they have received from Mid Staffordshire Hospital. So all of these are important things. They quite literally often make the difference between life and death, and they are central to the quality of life that our citizens have. So let's turn now to the context of Brexit and what the implications might be for some of these protections. In one sense, I mean, we've talked about the European Convention on Human Rights and the wording that's used in the political declaration. In one sense, you have to wonder why this is even an issue at all, because, of course, the ECHR is not the creature of the European Union. It is the creature of the Council of Europe, an organisation to which this country subscribes and which involves 47 European countries 40% of whom are not members of the European Union. So one wonders why it's even being talked about in the context of Brexit at all. And there's been a suggestion that perhaps the commitment to the ECHR, if it's taken seriously, is in some way an encumbrance, a hindrance on the process of government and prevents the government acting freely. And I know that some on the rather more extreme wings of the BrExit movement would suggest that this is a foreign intervention on the ability of an independent United Kingdom to do whatever it wants to do. Well, it's a good hindrance because it obliges us to conform to international norms of civilization which most people throughout the world actually subscribe to. And when you look at the United Kingdom's record in terms of complaints under the ECHR and judgments at the European Court of Human Rights, actually, it's a very good one. The United Kingdom is right down the bottom of the list of countries that have cases taken against them. So this, in many ways, our association with the European Court of Human Rights and with the process and the upholding of the Convention of Human Rights shouldn't be seen as some sort of hindrance. It should be a vindication, actually, of the fact that this country is actually quite good at holding people's human rights when it comes to how things are governed. There's also a concern, of course, that one of the reasons behind the debate on revisiting human rights legislation might be, as some people would see it, to free up the United Kingdom in terms of international trading arrangements in a post-Brexit scenario, in order to perhaps, I don't know, I mean, the International Trade Secretary is not doing that well in terms of signing up these agreements, but as time progresses, I'm sure there will be more come on our agenda. It is important, I think, now, at the very beginning, before we get into this, that we say we're not prepared to trade standards of human rights in third-party countries that we want a trade agreement with in order to secure trade with that country. We must be seen, surely, as a country that upholds human rights standards, not just in this country, but uses our power and our authority to be able to make sure they are upheld internationally as well. So for that reason, I would also like to see the Minister suggest not just that there's no intention to diminish the current protection we have, but to explore in a post-Brexit scenario, if indeed that comes about, how the human rights are going to be protected, not just in this country, but throughout the world. And of course, one of the problems here is that we're talking about something that to some extent has already happened. Last summer, when discussing the European Withdrawal Act, the government was very keen to make sure that the EU Charter on Fundamental Rights was not included in the British legislation, despite the opposition from my party and from many others. And the government's case, of course, was that, well, actually, all of these individual rights are replicated elsewhere anyway, so it's unnecessary, it's duplication. Well, notwithstanding the fact that that's not quite true, there are some rights in the EU Charter which are not in the ECHR, it misses the main point. The purpose of the EU Charter on Fundamental Rights is not just to define the rights that people have, it was to create obligations on member states of the European Union on how they would be upheld, and in particular to assert the primacy of rights over other legislation. And the QC Jason Koppel, in his advice that he provided for the Equality and Human Rights Commission, put this very clearly when he cites the case of cleaners in the Sudanese embassy who had tried to go to court in order to uphold their employment rights, who were told that they didn't apply because of the 1978 Immunity Act, where foreign embassies were exempt. They used the Charter to go to court and argue and to win their case that, in fact, their employment and human rights at work were more important than the Immunity Act, and that latter act should be set aside in order to ensure their rights. Now, the tragedy is that if we go ahead and exit on the 29th of March at 11 p.m., the Charter's gone. It no longer applies. So those cleaners would not be able to take that case that they did in 2017 in the future. And that is a diminution of the rights that people have. Can I just, in the final part of what I want to say, I believe that it is vitally important that we are not complacent about this, that we look at ways in which we can strengthen and develop the application of human rights in our country. And to that end, I want to say something about the situation in Scotland, because I believe developments are happening there which can provide some leadership to the rest of the United Kingdom and indeed to the other nations within the United Kingdom. Now, the Human Rights Act itself, of course, is a reserved matter for the whole of the United Kingdom. But the European Convention on Human Rights, which the HRA enshrines, is fundamental to the devolution settlement in Scotland and in Wales, and, of course, to the Good Friday Agreement in Northern Ireland as well. Scottish ministers are required to comply with the ECHR in everything that they do. And for that reason, and also for the simple reason that the upholding of most people's human rights has an awful lot to do with the processes, the day-to-day processes of government. For that reason, the Scottish Government is very keen to look at how human rights can be developed and incorporated into Scots law. And there is a recent report that's just published before Christmas from the Scottish Government's Advisory Committee on Human Rights Leadership, chaired by Professor Alan Miller, which I would recommend to colleagues to have a look at. It is a very good report, and it sets an agenda over the next 5 years as to how this matter can be taken forward. It sets 3 central principles in the context of Brexit. The first is, as we've already discussed, that there should be no regression in human rights protection as a result of Brexit. But the second, which we often don't talk about, is that we need to keep pace with any improvements in human rights protection in the rest of the European Union. So it's a matter also of having policies in place to ensure that this country does not lag behind the EU 27 or indeed the Council of Europe 46 if things are happening in that basis. So we need to keep pace. And the third theme that it talks about is how really to make it real, how to integrate human rights protection into the very processes of government itself. Now, the report splits human rights into different categories. The one that people are most familiar with, of course, is civil and political rights. You know, the right to life, the right to vote, the right to free expression. And these, of course, these are central to the ECHR and to the Human Rights Act itself. But, of course, there's a whole other dimension of human rights that we talk about, social and economic rights, the right to health, the right to shelter, the right to work. People talk about these as well as being rights that are essential to defining the nature of the society in which we live. And this report is very instructive in that it begins to take that debate forward so that these rights aren't just talked about as abstract principles, as objectives to be attained, but actually government policy is shaped towards their delivery. Now, I'm happy to debate this point. There may be some colleagues here from the libertarian right who can put an alternative point of view, but to my mind, delivering on these social and economic rights has to bring up the question of the regulation of resources in society, because essentially what these rights are about is a fair allocation and sharing of resources between people. Now, that doesn't mean that it's the government's responsibility to provide everybody with the keys to a 3-bedroom house, okay? But it does mean that it ought to be the government's responsibility to ensure that there is a public policy framework for housing, the objective of which is that everyone should be adequately housed. And it should also be the government's responsibility that in cases where regulation or the market fails to achieve that objective, there is a safety net provision in order to provide basic shelter. And in order to test whether government policy is actually delivering on those rights, we need to make sure that the notion of human rights is integrated into government at all levels. So I would finish with this point, really, because I think there is much that can be learned from what is happening in the Scottish debate, and perhaps the Minister will want to comment on it and to suggest whether that debate might be able to happen in the United Kingdom as a whole. But what is central to this is the fact that human rights cannot be seen as an add-on to policy, not as an afterthought. They need to be central to the policy of government at all levels. And that means perhaps in the future it won't be a minister from the Justice Department who's responding to this debate. It would be more fitting to have somebody from the Cabinet Office or the Deputy Prime Minister or the Prime Minister themselves, because it needs to be driven into every aspect of government policy. It shouldn't just be seen as something that exists it's a concern of lawyers of the legal department. It has to be central to how we do the business of government. And I commend this motion to the House.
This House has considered human rights in the UK. I'm conscious that there are several members who wish to speak. I intend to move to the front bench wind-ups at 3:28. And therefore, I would just advise you, if you all are going to speak, you'll have to have relatively concise contributions. John Howell.
Thank you, Mr. Gapes, and it's a pleasure to serve under your chairmanship. And it's also a pleasure to follow the honourable member, who is a fellow member of the Council of Europe with me, so I can understand some of what he is saying, and actually agree with a lot of what he's saying. The convention, of course, has been around since the early 1950s, and it's just worth remembering that it was 1965 when we agreed to abide by its decisions in the UK. So we've had almost 60 years of relationship with the Court of Human Rights and with the decisions of the human rights. But the point that I would start off by making is that the Convention is not the same as the HRA, and the EU is not the same as the Council of Europe. The two are very different, and we should take them as being different. Now, I have a lot of time for the Convention, and I agree with much of what he said about the Convention. And I was particularly irritated during the referendum campaign that a lot of people got the ECHR confused with the European Court of Justice. The two are completely separate. One is owned by the European Union, and the other is owned by the Council of Europe, as it were. Now, I would actually go on to say that the single biggest contribution to peace in Europe since the end of the Second World War has come from the Convention on Human Rights, together with work that NATO has been doing. And I think that we should state that, and we should be proud of it, because it was something that we were very much involved with from the beginning. And as the honourable gentleman and I know only too well, the European Court of Human Rights comes with a democratic mandate. He and I spend a lot of time, I imagine he spends a lot of time, as I do, voting for the judges that are put up in order to sit on the European Court of Human Rights. And that gives a democratic control, but also is a means of reflecting, to a certain extent, a mixture of politics and competence and a whole number of things that give the European Court of Human Rights its particular character. I am not as enamoured at all of the EU involvement with human rights. I think that has created a very mixed picture. And I think if it's not using the term wrongly, I think that the European Union has tried to steal the mandate of the Council of Europe in this, which, as he and I know, applies to almost twice the number of countries that the EU does. And I think that has a large part of its strength there. And, of course, the relationship between the EU and the European Court of Human Rights is something that we are still debating at the Council of Europe. The UK involvement with the European Court of Human Rights has been a huge success story, as he rightly points out. And it has been a very good illustration of how, actually, human rights overall are doing quite well in this country. I don't agree with him on the need to extend those human rights to things like housing. I think, to be honest, that is a route of socialist involvement in the running of this country that I do not agree with, and I would steer clear of. But I will briefly, of course.
Does the honourable gentleman recognise that there are countries across the world, such as South Africa, the new South African constitution, and also some of the Nordic countries that have a right to adequate housing in their constitutions. Would he consider these to be socialist countries?
Well, when the EU decided to bring out its own human rights framework, it thought very carefully about what should be in there. And actually, with only a number of a few exceptions, did it differ from what the European Court of Human Rights did. I will give way.
When the ECHR was opened for signature in November of 1950 in Rome, the government, of course, in this country from 1945 to 51 was a Labour government. So will he praise the socialist government under which the ECHR was originally conceived?
I think the Honourable Gentleman plays politics with human rights, which I think is unworthy of him and unworthy of this chamber. But if I can return to the issue that I was talking about, which was the success of the British government with the European Court of Human Rights, something like 90% of applications that are brought before the European Court of Human Rights are deemed unacceptable and are not taken forward. And of those that are taken forward since 1975, a quarter of those in a quarter of those, the European Court of Human Rights has found no violation at all. So our track record there is particularly successful. Now, there are two cases that I would like to bring up because they illustrate the extremes of the Council. The first is the Gurkhas, who a few years ago, members may remember that we moved their headquarters back to the UK, and we moved their pensions onto the same basis as UK soldiers. And they took their case to the European Court of Human Rights, who looked at their case and decided that there had been no real discrimination undertaken against them. And they found for the British government in that. But in a similar, in a slightly different case, the UK's mass surveillance regime that it uses as part of its security operations, the European Court found that the UK had violated the Human Rights Convention and had asked for some changes. Now that brings us on to a very tricky issue, and that is the role of human rights against legislation to look at terrorism and how to deal with that. And I agree with the Honourable Gentleman that when we look at this, it should be looked at in the context of what makes us a much better world to live in. And I'm not one of those who believes that tearing up the Human Rights Convention is the best way to protect us against terrorism. But having said that, he will know that at the last Council of Europe meeting, when the issue came up of whether we deprived those who had gone to fight with ISIS of their passports, I enthusiastically supported that motion and that we should not have them back. So the role of human rights in this plays out at different levels and in different ways. Now, if one looks at the way in which the Human Rights Court works, the first thing that you have to make sure that people understand is that you have to have exhausted all the domestic remedies first. You cannot go straight to the European Court of Human Rights. You have to have exhausted all domestic remedies first. And there has to be an alleged violation against the Convention. And there has to be significant disadvantage that comes out of that. So in the response that I would like to hear from ministers, it really does go back to what they have already said. And indeed, I think it was this minister who specifically said the UK will remain a party to the ECHR after it has left the European Union. The decision to leave the European Union does not change our strong commitment to recognising and respecting human rights. I'm not sure whether the Minister remembers making that statement, but it was in the main chamber on a question from the member from Carshalton. And I agree with him wholeheartedly on that. Human rights are too important to be used as a political football in this game of Brexit, or indeed in anything else. And that we have a long and very successful track record of using our involvement with the European Court of Human Rights, of using our long relationship with the Council of Europe that looks after it, and of protecting the interests of British citizens.
Rachael Maskell.
Thank you, Mr. Gates. I'm grateful to have you serving us in the chair and to serve under you this afternoon. And may I also congratulate the Honourable Member for Edinburgh East in opening today's debate. I certainly have concerns about the loss of the EU Charter of Fundamental Rights, no less the Article 25, which I've been campaigning about, the right of older people. And I've been campaigning to see a commission for the rights of older people in our country, very much voiceless within our institutions, and it's somewhere where we need serious reparation. Today I'm going to take a different perspective, and people will be glad to know that I'm not going to talk about Brexit, but I'm going to talk about my city of York, which became the UK's first human rights city on the 24th of April 2017. And currently there are 41 cities across the world, 9 in Europe, which are human rights cities networked together. It's something we're incredibly proud of, building on a strong legacy. And I certainly hope in setting out what a human rights city is, honourable members will be encouraged to take that message back to their own cities to develop such a case as Swansea are currently. A human rights city itself was built on a legacy. We became a city of sanctuary in 2016. We've had York's Traveller Trust, which has done incredible work representing travellers and gypsies in our city. The LGBT Forum in York has been a place of welcome for LGBT asylum seekers and refugees, to bring them together in a safe space in York. And the University of York has a global reputation. Its Centre for Applied Human Rights, which famously has its Protective Fellowship Scheme, which brings human rights defenders from across the world to the university in order to not only have some space, some thinking space, to make sure their human rights activity is sustainable globally, but also to have some intellectual rigour to look at the best practice around human rights defenders across the globe. And one thing I would certainly ask the Minister is that we don't have these real challenges in order to get visas for these individuals coming to the UK to be able to have that space. We are humbled when we hear of the work they're doing, whether they're journalists or human rights defenders or people working in their court systems, and they come to the UK to have some respite, but also to advance their human rights practice. And yet, time and time again, visas are blocked because they have not the resources, although they do have people who are willing to sponsor them here. And it seems a shame that doors are shut when we should be really extolling the incredible work that they do. But we, as a human rights city, have signed up to a charter to work in areas around the domestic human rights agenda, and therefore I do take issue with the member for Henley about the importance of these issues, because human rights in the UK must apply at home as well. And therefore the 5 areas which York has chosen, these not are subscribed, are looking at equality and non-discrimination, education, decent standards of living, housing, and health and social care. York, in becoming a human rights city, embraces a vision of a vibrant, diverse, fair and safe community built on the foundation of universal human rights. It's a vision that's shared across citizens and our institutions in our city, from the council, the police, the voluntary sector and the faith communities, putting fundamental rights at the heart of policies that are passed by these authorities and building on hopes and dreams. And of course, many who will know the history of York, this follows in a strong legacy. If we think of housing in York, this is such an important issue to us as a city, where the Rowntree family, and I'll talk about the Rowntree family, they built the first garden village in our country, New Earswick, and that's stimulated the 1919 Housing Act, which was the foundation of social housing in our country, and then built forward into Town Hall, where they took that model further into the city. As a city, we've had pioneering mental health services, first at Bootham Park Hospital, established in 1777. And when a patient tragically died there, the Quaker movement said, we can do better, and they set up the retreat. And therefore, there's been this competition about advancing the human rights of people with mental health challenges in our city to this day. And then we had Stephen Rowntree, who many will know, wrote 3 incredibly powerful reports looking at the issue of poverty, and the Joseph Rowntree Foundation follows those through to today. But even in 1899, looking at poverty, a study of town life, they talked to over 46,500 residents of York looking at the serious poverty in our city. What an incredible study that was, taking the stories as well as statistics at trying to advance our city. And then we had Joseph Rowntree himself, yes, of chocolate fame, but he himself set up what good practice work should look like in our city, not only providing jobs with decent pay and pensions and healthcare and education and housing and a park and theatres and the arts, a swimming pool and decent conditions, because he understood, as his family understood, the real importance of that holistic agenda about advancing individual rights. And he sowed that legacy into our city, and that's why we're proud to be the UK's first human rights city. But we are on a journey, and it's fair to say there is a lot that we need to achieve. And therefore, as we map our way forward, we are looking at statistics and stories to take forward the challenges our city, quite frankly, needs to see improvement. Over the last year, we have seen wages fall in our city by £65, causing greater economic inequality when we are already the most inequitable city outside of London. Using a human rights framework looking at economic disadvantage, we are going to be advancing the opportunities for people in our city. We have a gender pay gap of £117. That has got to be addressed above national average. We have looked at the issue of food bank use, up 25% in the last year, with over 4,000 residents requiring use of a food bank. How can that be ignored when we're looking at a human rights framework? These are fundamental issues facing our society today. Look at the issue of life expectancy. In our city alone, there is an 8-year gap in life expectancy. In the wards of Clifton, in Westfield and Town Hall, men will die 8 years younger than their counterparts, economically disadvantaged and health disadvantaged. We look at the issue of education, and already, using the human rights framework that we have established, we have seen NEETs, those not in education, employment and training, fall, which is a real positive implication, because we have tracked through the causation and therefore put in the restorative means in order to get more people into work. And yet, in York itself, we have received from government the worst funding for our schools in the country, and in areas where we have the lowest attainment and we have the biggest attainment gap in the country, we are not building for a legacy for the future. So I do urge the government to have a look at the data and to make the links between funding and attainment, as our human rights framework clearly does. Look at social care, and of course the cuts to social care has had a real impact, again going back to those fundamental rights, and we know that contact with social care services has fallen in our city. And then coming on to the important issue of housing, what it has demonstrated in our city is that whilst a low-wage economy, we do have high skills, and therefore we have underemployment, which then makes it harder itself to be able to access housing, because we have a very high cost of living, 10 times a wage in order to purchase a property in York, and indeed incredibly high to rent. And therefore we have poor access to housing, and therefore we have greater inequality being built between the haves and the have-nots in our city. So we're using a human rights framework in order to advance opportunity of people in our city and to map the way forward. Since being established in 2017, we've established a Human Rights and Equalities Board. We've developed something called Community Voices, ensuring that those that are never engaged in our democracy, those people whose voices are silent, are at last being heard, reaching out particularly to the homeless, people who are disabled, women and young people. We've also are supporting other places which are hoping to develop this framework in order to mark their own city's advancement on the issue of rights. York has been built on its history and its social traditions, and we want to see that legacy move forward as we move on that journey. And our party in the city really has a vision of building a fair city for the future and reenacting and repeating that work that Seaborn Roundtree did, and looking at how we can make York a fair city in the future.
Thank you. I'm conscious we have three people who wish to speak. If you can keep your remarks to just about 5 minutes, that might, with the interventions, allow our front benches the time. I do intend at 3:28 to call the first of the front bench speakers. Jim Shannon.
Thank you, Mr. Gibbs. A pleasure to speak in this. I'm just a bit perturbed that my time has been cut, but that's by the way that's been done. Thank the honourable gentleman for Edinburgh East for bringing it forward. Whereas we are certainly a champion of human rights in this country, there are certainly cases which show us that we're not where we should be. I'm minded that next year is the 400th anniversary of the journey of the Mayflower. On September 1620, a group of 102 people, 30 crew members, set off across the Atlantic to seek opportunity and to escape religious persecution in the UK. 400 years later, we still have some problems. There are also cases which show us that one person's human rights should not be laid on the altar of someone else's perceived rights. An example of this has been the case in Northern Ireland, Asher's Bakery, and the question was raised, do we still have the right to refuse to serve based on a message which directly contradicts a sincerely and dearly held faith? After much legal wrangling, the case upheld the right to refuse a message but not a customer. The idea that you can be forced to advocate for something that you do not believe in is fundamental, and that decision was a very, very important one. The case was taken to the UK Supreme Court, and in a unanimous decision, 5 of the UK's most senior judges upheld Asher's appeal against claims of discrimination. They agreed the objection was being required to promote the message on the cake. The less favourable treatment was afforded to the message and not to the man. Nobody should be forced to have or express a political opinion in which he or she does not believe. That's what the court said, and it's very important that we have that there when it comes to human rights in the United Kingdom at this moment. Whilst this case was ostensibly about a message on a cake, a section of Christian people were fearful this was also about an impact on their right to hold their belief and live this belief out. We are so good sometimes at protecting the rights of everyone to live their beliefs in as much as they are not harmful or destructive. And yet increasingly we have a section of the UK that begins to fear what can be said or not said when it comes to their Christian beliefs. A 78-year-old preacher in Northern Ireland was questioned and tried for preaching from his pulpit regarding the biblical story regarding hell and the fact that if you don't have a faith in Jesus Christ, you cannot get to heaven. His case was found not guilty. Again, another example of human rights. We have registrars who have lost their jobs as they cannot oversee the marriage ceremony of same-sex couples, which is against their health beliefs. There are other people who are happy to do this, and yet these people have lost their employment. It is little wonder that Christians are questioning their human rights when all would seem to say, believe anything you want, tolerate everything possible, except for something based on the Word of God and their personal and heartfelt beliefs. The court cases have proven that this is not the case. We must question how these cases get to court, and this is why there's a real fear within Christian circles at this time. I've heard more than one Christian preacher who has warned his congregation that a time is coming when all will be persecuted for their faith. And I can see that many people believe this will happen in this country, in the United Kingdom of Great Britain and Northern Ireland. I'd like the message sent today and very clearly and specifically said that this will not happen in this country whilst we are still a democracy, that we will allow people to hold on to their belief and live by it as long as there's no harm to others around them. This nation was founded on biblical principles. From the time of Alfred the Great, it is time that we reminded people that whether we personally believe or not, Christians will not be persecuted for living their faith in the same way that we do not allow the persecution of other religions. This, I believe, this goes without saying, and yet a growing section of our community need to hear this said in this debate today and for this purpose. When we talk about human rights, we also must speak out for those who have been persecuted because of their religious views and for hard-held views that they have. And I think it's very important this matter is put on record. Mr. Gates, thank you.
Alex Stewart.
Thank you very much. It's a pleasure to serve under your chairmanship, and I pay tribute to the honourable gentleman for leading this debate. So I want to say a few words, if I may, about the European Convention on Human Rights. And I say at the outset that I'm very much a supporter of it. And I think it's important to emphasise that the values that we see in the European Convention are very much British values. If one looks, for example, at some of those rights that are contained within it, the right to life, sounds fairly British to me, the right to avoid torture, inhuman or degrading treatment, Article 3, again, I think we could probably sign up to that. The right not to be subject to slavery, Article 4, the right to liberty and security, Article 5, the right to a fair trial, and so on and so forth. And I think all too often this debate has been tainted by a misunderstanding of what the actual rights are themselves, as if they are a foreign import that don't reflect some of the cultural norms in our country, and nothing could be further from the truth. And that's emphasised by the fact that certainly in my experience in court, and I dare say in the experience of plenty of the other distinguished practitioners in this room today, it is overwhelmingly the case that any submission that is supported by, for the sake of argument, Article 6, is very often buttressed by domestic legislation as well. So in the criminal courts, if you're seeking, for example, to exclude evidence relied upon by the prosecution on the grounds that it would deny you, your client, the right to a fair trial, well, it may very well be that in tandem with invoking Article 6, you'll be relying on Section 78 of the Police and Criminal Evidence Act 1984. And indeed, although the honourable gentleman was absolutely right to point out individual cases where rights have been asserted in order to achieve a remedy, in the overwhelming majority of cases in our country, it is the domestic legislation that does perfectly well and may be supported to some extent. But as I say, it's rare that the right of itself would found the claim or found the application for a remedy. Yeah, of course.
I'm grateful to the honourable gentleman for giving way, and I think he's entirely right in his assessment of criminal law. I think the one area, though, where certainly the Human Rights Act, in the sense of the incorporation of the ECHR into UK law, has made a big difference in and of its own is in family law, particularly in rights to see children.
I think that's right, and there are areas where there's been a greater role for it. But I did just want to slay the myth, as it were, that people are routinely invoking Human Rights Act points to seek remedies that aren't otherwise available in the legislation. And yes, there are examples of that, but they're by no means the norm. But where I think the Convention is so important is because it provides that important safety net at a time particularly of national stress and national crisis. Because one of the things that we know is, supposing there is a terrorist atrocity, the cry immediately goes up that the state must act ever more robustly, often impinging upon individual liberties. Now, sometimes that's the right judgment to make, but equally it's critically important that any measures that the state is proposing to take are viewed through the prism of what we view to be our keenly won liberties. And it's not just a British phenomenon. If one thinks of the United States in the Second World War, one of the episodes of which it has now, I think, the most shame was the internment of Japanese Americans at a time of national stress. But in our country, we're not immune to it. So in the aftermath of September the 11th, there was legislation in the UK that people will remember, the Anti-Terrorism, Crime and Security Act, Part 4, which was used by the then government to effectively hold people without charge. Now, that ultimately was challenged in the European Court of Human Rights, and the court ruled that that was unlawful because it breached Article 5. Now, again, it seems to me that that provides a useful safety net. Yeah.
I mean, in my lifetime, members of the Catholic community in Northern Ireland were interned without trial, with some quite impact on family life. Does he agree with me that that's something that the ECHR has made a big difference to in the United Kingdom, and as a result of our membership of the ECHR and the direct effectiveness of its rights, the direct applicability through the Human Rights Act, it wouldn't be possible for us to intern without trial in the UK?
I think it's a really important point, and we have to recognise in this place that because necessarily in a democracy we listen to our constituents and we reflect their concerns, that this House will always have a tendency to react in a very public way towards what is perceived to be a public need. But it is not wrong that there should be a check to that and a requirement for sometimes for us to give pause for thought. And I will just close, however, by saying this, that insofar as we give to the courts great power, and also to the European Court of Human Rights great power through the Convention, it is right too that they should exercise necessary discretion. And there have been examples, I would respectfully suggest, where they perhaps strayed beyond what might have been the natural area of competence. And the most obvious example is the Hurst example, where to invoke, they relied upon Article 3, which of course is the prohibition against torture, inhuman and degrading treatment, to rule that the British government was in error in saying that prisoners couldn't vote. Now, there are a number of people who might think that that had gone too far and that there hadn't been appropriate respect for the principles of subsidiarity and the margin of appreciation. I'm not going to go into that now, but certainly there is a case for saying that the court ought to tread carefully, and I would invite them to do so. And the real reason why I'd invite them to do so is because what they do and the rulings they provide, I think, overwhelmingly contributes to human rights in this country and to the quality of our public discourse and to the quality of our democracy. And it would be a crying shame if unfortunate judicial activism were to put that at risk.
Kate Osamor.
Thank you, Mr. Gapes. It's a pleasure to speak under your chairmanship. And I thank the Honourable Member for Edinburgh East for bringing this important issue to the House. I am deeply concerned by the huge hole that will be left in human rights protection after Brexit, especially in the event of a no-deal Brexit. But even while the UK remains a member of the European Union, human rights have been considerably worn down through austerity policies. Only because we haven't got a lot of time. Only last year, the UK, according to Professor Alston, the UN's rapporteur on extreme poverty and human rights, was found in breach of 4 UN human rights agreements, those relating to women, children, disabled people, and economic and social rights. The critiquing report also drew on work by the Institute for Fiscal Studies and the Joseph Rowntree Foundation to highlight in predictions that child poverty could rise by 7% by 2022, possibly up to a rate of 40%. Such levels of poverty, actually and projected, were, he declared, and I quote, not just a disgrace, but a social calamity and an economic disaster. Such reports agree with the experience of my constituents. Enfield Council has already made £178 million worth of savings since 2010 due to funding cuts from central government. But further cuts means the council is currently having to find another 18 million to draw out of essential services by 2020. 18 million is more than Enfield's current net spend on housing services, leisure, culture, libraries, parks and open spaces combined. The impact on cuts on young people is tragic. Youth services have been decimated and young people are abandoned as essential staff have had to be shed and simply a skeleton service is provided. Austerity in education in Edmonton has created an £8.5 million annual funding shortfall. Every single school in my constituency has had funding cuts since 2015. That means, in an already struggling community, the education of every single pupil in Edmonton has been undermined. All this and much more has been done while the UK still has the protections of the EU Charter of Fundamental Rights. The Human Rights Act is woefully insufficient on its own, and I dread what could be done to our communities without the limited protection the EU Charter provides. So I ask the Government Minister, in his summing up, does he not recognise the limitations of the Human Rights Act without the protections of the EU Charter of Fundamental Rights? And can he explain how his government is preserving these rights before the UK leaves the EU? Thank you.
Joanna Cherry.
Thank you, Mr Chairman. It's a pleasure to serve under your chairship. I'd like to begin by congratulating my honourable friend, the member for Edinburgh East, in securing this debate today. And I'd like to also say that we've had a diverse range of contributions from the honourable members for Henley, York Central, Strangford, Cheltenham and Edmonton. And I was particularly interested to hear about the concept of a human rights city, which I wasn't aware of, and I'll certainly be looking at that as something that Edinburgh could think about. And I was also very pleased that the Honourable Lady for Edmonton mentioned the report and the findings of the UN Rapporteur on Poverty, because I think there's something that we all have to bear in mind very carefully as we proceed with looking at how we run our economy and our society. Mr Chair, I think this debate is very timely because Parliament's convulsed in a bit of a state of indecision at the moment about whether to go for the Prime Minister's deal, no deal or no Brexit. And everybody's talking about the backstop. And in that context, I think it's really important that we don't lose sight of the clear risk which Brexit poses to regression in terms of rights, of human rights across the United Kingdom. And I think it's also very important to remember the threat that Brexit poses to human rights in Northern Ireland. At least one speaker today has pointed out how integral to the Good Friday Agreement the recognition of human rights are. And if anyone's interested in that, I would highly recommend the briefing paper on the Good Friday Agreement, Brexit and Rights by Professor Christopher McCrudden, the Professor of Equality and Human Rights Law at Queen's Belfast. It was a paper that was published by the British and Royal Irish Academy, and it makes very interesting reading. Chair, I do believe that human rights are in a precarious position in the UK at the moment because despite a clear commitment from the Prime Minister that Brexit wouldn't result in a diminution of rights protections, the UK government has not to date lived up to that commitment, both in the context of Brexit and more widely, as we see from the UN Rapporteur's report, and also the huge concern caused by the Windrush scandal and other aspects of the hostile environment policy. And I think the government, many of us fear that the government has refused to engage in people's concerns about the impact of Brexit on human rights. And it is concerning that whilst the Human Rights Act is said to be safe for the duration of the Brexit process, recent events have made it clear that the current UK government hasn't lost sight of a long-standing desire on the part of some in the Conservative and Unionist Party to repeal and replace the Human Rights Act. But in the meantime, what we do know for certain is that if Brexit happens, we'll be losing the Charter of Fundamental Rights. And that charter protected a wide-ranging list of fundamental rights and principles, covering certain social and citizen rights, which went considerably further than the ECHR. And I know that the UK government have tried to argue that the Charter didn't add anything to the corpus of UK law, but this is demonstrably false. Even if one looks at the UK government's own right-by-right analysis from 2017, it highlights just how limited UK domestic protections are in certain key areas. And that is not just my view, it's a view that was echoed by the Joint Committee on Human Rights, of which I am a member. Now, of course, in Scotland, the Scottish Parliament tried to preserve the benefit of the Charter of Fundamental Rights on or after exit day insofar as it applied to retained EU law in Scotland, and they did so in a bill of the Scottish Parliament called the Continuity Bill. But most regrettably, Chair, that bill was objected to by British law officers, held up until such times as the EU Withdrawal Act had been passed, and that retrospectively changed the powers of the Scottish Parliament so that the Continuity Bill, insofar as it attempted to preserve the Charter in Scotland, was ultra vires. And I think that was a very retrograde step. And if anyone says that Brexit hasn't been used as a power grab on the Scottish Parliament, then the UK Supreme Court have very clearly said otherwise. But the Brexit process threatens human rights protections across the UK, not just by repealing the Charter, but also because of the wide range of delegated powers that are afforded to the executive in the Brexit process. And as the Withdrawal Act stands, it would allow the amendment of important domestic rights legislation, such as the Equality Act, the Modern Slavery Act, and the Data Protection Act, with little or no parliamentary oversight. And that is so because despite the efforts of many of us to try and amend that Act, it doesn't contain any clear prohibition on the use of delegated powers to erode rights protections. So the repeal of the Charter, the risks of delegated legislation, government obfuscation on rights issues, also as a result of Brexit, threatens our human rights in the United Kingdom. Again, don't just take my word for it, the Joint Committee on Human Rights have criticised the government over its report on human rights and the implication of Brexit. And the committee said back in 2016, it's regrettable that the government has not been able to set out any clear vision as to how it expects Brexit will impact on the UK human rights framework. And in the same report, the Joint Committee on Human Rights went on to find that the government seemed unacceptably reluctant to discuss the issue of human rights after Brexit. And the Minister of State responsible for human rights was either unwilling or unable to tell us what the government saw as the most significant human rights issues that would arise when the UK exits the EU. And this unwillingness to commit is of particular concern when we look at the question of future trade deals with third countries, because many of us fear, as the JCHR hinted at, that this unwillingness to discuss the issues in detail is suggestive of a government which wants to prioritise trade deals over human rights. And of course, that's not just important in relation to the message it sends out within the UK, but it's also important in relation to the message that's sent out across the world if the United Kingdom is not prioritising human rights. Now, my honourable friend for Edinburgh East also mentioned concern that has recently raised its head again about the government's long-term intentions in relation to the repeal of the Human Rights Act. And Mr Chair, in those dim and distant days before Brexit, when it's difficult to remember what we all talked about in here, that was, of course, a huge issue. Back in 2015 and 2016, the current Prime Minister's avowed desire to get rid of the Human Rights Act and the big question mark she raised over whether Britain would even continue to observe the ECHR was something that involved us all in a lot of debate. And it seems that it has merely been put on the back burner, and that's very concerning. Now, as my honourable friend said, in Scotland under devolution, there have been two pillars granting human rights. First of all, the membership of the European Union, and secondly, membership of the ECHR. But now Scotland faces being taken out of the European Union against the will of the majority of Scots, and there's still a big question mark over the depth of this government's commitment to the ECHR. Yet, in the midst of these threats to human rights, these are things which the majority of Scottish voters have not sought or supported. But it's good to know that the Scottish Government, as my honourable friend said, is showing a way forward with this. And for a number of years now, the Scottish Government has had a national action plan for human rights. And now, just before Christmas, the advisory group to the Scottish Government on human rights have published a report suggesting a new human rights framework for Scotland in the future. And it's noteworthy, Mr Chair, that the advisory group were asked by the Scottish Government not just to make recommendations about civil and political rights, but also to look at social, cultural and environmental rights, and also to consider if and how to incorporate rights arising from the United Nations treaties into Scots law and governance. And as my honourable friend said, in recommending the next steps on Scotland's human rights journey, the report of the advisory group set out three guiding principles. Those principles were that Scotland should not regress from the rights currently guaranteed by membership of the European Union. Secondly, that Scotland should keep pace with future rights developments within the European Union. And thirdly, that Scotland should continue to demonstrate leadership in human rights. And my question for the Minister today is, will he look at each of those three principles and tell us whether the UK government could sign up to those principles for the whole of the UK? Could the UK government agree that the whole of the UK should not regress from the rights currently guaranteed by membership of the European Union? Could the UK government agree that the whole of the UK should keep pace with future rights developments within the European Union? And could the UK government agree that the UK should continue to demonstrate leadership in human rights? That is the sort of clarity that the Joint Committee on Human Rights and others have been calling for. And I'd like to have that clarity from the Minister today, and I'd like him to tell us if the UK Government can't sign up to those principles, why not? Thank you.
Thomas-Symonds.
Thank you, Mr Gapeson. It's a pleasure to serve under you as Chair, and I'm grateful to all members who contributed to what has been on the whole a very fine debate on human rights this afternoon. And I warmly congratulate the member for Edinburgh East on securing the debate and indeed for his speech. And I think he picked out powerfully why it is so timely, because of the worry that there will be a rollback of rights, that the EU27 will indeed move ahead and enhance rights, and we in this country will fall behind. I thought he spoke well too about the Prime Minister's ambiguity, to say the least, on this matter, which is something I will return to in a moment, and also picked out some really strong examples of practical cases where the Human Rights Act, the incorporation of the ECHR into UK law, has made a difference to those seeking justice in this country over the past 2 decades. I'm grateful too to my honourable friend, the member for York Central, and it's great to hear about the Human Rights City initiative in York. I congratulate her and all those involved in that initiative, and indeed to hear about the Human Rights and Equalities Board and all the other work that is going on really is something we must look at spreading around this country. Also grateful to my honourable friend, the member for Edmonton, and the report of the UN Special Rapporteur on Poverty really should make us wake up to the endemic problems of poverty in this country. And when she says about those human rights agreements being breached, women, children, disabled people, economic and social rights, it is a stark reminder that rights are, of course, critical, but they are paper rights if people do not have the means with which to enforce them. And I think it should tell us something, actually, about economic policy of the last 9 years, when an outgoing Lord Chief Justice can say that our system of justice is unaffordable to most, and that should say everything that we need to know and be a matter of great alarm. I'm also grateful to the member for Henley, talking about his experience on the Council of Europe, the member for Strangford, who spoke, I thought, very movingly about religious persecution. That's something we should all be vigilant about. Whilst he's not in his place now, the honourable member for Cheltenham, who, whilst I didn't agree entirely with all his arguments, I certainly agreed with him on his support for the European Convention. And I do think, Mr Gapes, we have to go back to first principles when we talk about the European Convention on Human Rights. And it grew out of a desire after World War II, a very noble objective, that what had happened should not happen again. And as I said in an intervention to the honourable member for Henley, it was part of the many different initiatives of the post-war government to put that never-again spirit into practice. But just to show that I'm always even-handed in the way that I deal with the history of it, when you look at who supervised the drafting of the original ECHR, one of them was actually a Tory. It was David Maxwell Fyfe, and he, as a British MP and lawyer, took part in that. And I do wonder what on earth he would make of some of the modern-day Conservative Party's ambiguity towards this initiative. Because when we look at it, and I think the honourable member for Cheltenham touched on this, what does it actually say? What does the ECHR actually protect? You know, the respect to life, against torture, against servitude, liberty and security protected, the right to a fair trial, the right not to have legislation applying retroactively, the right to privacy, freedom of conscience and religion, freedom of expression, association, right to get married if one wished to, effective remedies, protection against discrimination. Who could disagree with any of that? And my challenge always was to those who say that what we should be doing is having a British Bill of Rights, which of those rights would you take out and not put into a British Bill of Rights? And I remember asking that question when I first came into Parliament in 2015 of ministers. Answer, there never came any. Yes, of course.
Does he agree with me? Because, as I said, I'm a great champion of the convention, that although it was written immediately after the Second World War, there is not a single thing in that that doesn't apply to today.
I'm happy to find some agreement with the honourable gentleman for Henley, because yes, they do all still apply today, and that's precisely the point I would make. Why on earth would anyone want to change any of these time-honoured principles that, and that's what they are principles. Of course, we can debate how some of them are applied and so on and so forth, but those principles are as important and as relevant in 2019 as they were in late 1950, when the Convention was opened for signature. The Human Rights Act 1998 is also seminal because I think it's important to understand precisely what the situation was before then. I think the Honourable Member for Henley said it was in 1965 that firstly our court started following the actual judgments, but of course the problem was between the early 1950s and it was October 2000 when the 1998 Act came into force, was that if one wished to enforce any of these rights, you had to go to Strasbourg in the first place to do it. And the big change that came about in 2000 was the ability to go to our local courts to be able to enforce it. And what that meant is it made it cheaper, easier, and more efficient to enforce these rights that have been held by our citizens for so long. And that was a seminal change. And where I did part company from the Honourable Member for Cheltenham, who is right in one sense that, of course, these rights buttressed common law rights that were already here in the UK, there are numerous examples. The Honourable Member for Edinburgh East referred to some of the cases, but also I pointed out the example of family law to the Honourable Gentleman, where the incorporation of the Human Rights Act into UK law has made a significant difference. Now, I can say that the Labour Party is very committed and passionate about the ECHR, us as a signatory to the ECHR, and indeed its incorporation into our domestic law. But there is real concern about the position of the governing party on this. And particularly the Prime Minister. And I mean, the Prime Minister, when she was Home Secretary in October 2011, said, and I quote, "I'd personally like to see the Human Rights Act go, because I think we have had some problems with it." So that appeared to be her first view. She wanted it gone. 2016, April, what did she then say about it? "So regardless of the EU referendum, my view is this. If we want to reform human rights laws in this country, it isn't the EU we should leave, but the ECHR and the jurisdiction of its court." And that's why we've ended up with the Conservative Party's 2017 manifesto position as it is. And I quote, "We will not repeal or replace the Human Rights Act while the process of BrExit is underway, but we will consider our human rights legal framework when the process of leaving the EU concludes. We will remain signatories to the European Convention on Human Rights for the duration of the next Parliament." So here is the opportunity for the Minister today in his response. We know what the position is for this Parliament, but we don't know the position for the next Parliament. Honourable Member for Henley says quite rightly that these are time-honoured principles. Why are these principles only good enough for this Parliament, according to the Conservative Party? Why are they not good enough for the next Parliament, the next 10 Parliaments, the next 20 Parliaments? And I do say to the Minister, I can say for certain that the Labour Party will always remain fundamentally committed to human rights, fundamentally committed to the ECHR and to the Human Rights Act and its incorporation into our domestic law. Can he do so in his response now?
Minister Edward Argar.
Thank you, Mr Gapes. Pleasure to serve under your chairmanship. And I congratulate the Honourable Member for Edinburgh East for this debate on human rights and the UK, and I've listened with great interest to the views expressed here, and I think we have a multiplicity of not only honourable but honourable and learned members offering the benefits of their legal expertise today. The Honourable Gentleman set out not only his case but also the broader importance of human rights as a concept, highlighting in that cause a number of specific cases and examples. And quite rightly, this is a subject of very real importance to all members of the House. I have to say it's something that I've taken a very close interest in within my portfolio, and it's an area that is not just intellectually fascinating, but as honourable members have said, permeates our national life. The honourable gentleman raised one particular issue about where this responsibility should sit, and I won't take his suggestion it should move personally. The reason it currently sits with the Ministry of Justice and with me is, although he's absolutely right to say it is a cross-cutting issue, in a sense the Ministry of Justice is a key defender of the rule of law, and that is what this goes to the heart of. However, I'm sure colleagues in the Cabinet Office and the Chancellor of the Duchy of Lancaster will have noted the points he made in his comments. Human rights, as many members have said in the UK, are not something new. The UK has a reputation as a leading exponent of human rights, both domestically and internationally, setting the highest standards. And as honourable members have set out, this didn't begin with the ECHR, the 1998 Human Rights Act, or our membership of the EU, and this position will not end with our exit from the EU. Human rights, of course, as a term, as a distinct term, may have started to come into common usage in this country in the 20th century and developed through international treaties and organisations. But, of course, the concept of rights in our country, and I might say responsibilities, goes all the way back to the Magna Carta in 1215, the Petition of Right in 1628, and indeed the Bill of Rights in 1689 in England and the claim of right in 1689 in Scotland. It has evolved over many, many centuries and years. Common law, of course, developed alongside statutes and set out rules developed by the courts governing relationships between people and government, which we would recognise today in many forms as rights. And we have a strong and proud track record in this area. And indeed, as the honourable member for York highlighted when talking about her own city and its university, it is, of course, something also rooted more locally in many of our communities. And I was particularly interested in the comments she made about the work the university and her city are doing in this respect. It was, of course, no less a figure than Winston Churchill, Mr. Gapes, who was one of the main protagonists for a new regional organisation that was to become the Council of Europe. Indeed, in 1942, he called for the enthronement of human rights, and in 1948 called for a Charter of Human Rights that would be guarded by freedom and sustained by law. The European Convention on Human Rights, as many members have alluded to, was drafted in 1950 by the Council of Europe to safeguard basic political and civil rights, and I am always educated, not just in matters of the law, but also in matters of history by the Shadow Minister, although I have to say in this case it is a coincidence that I did actually read David Maxwell Fyfe's memoirs over Christmas. I suspect I am probably one of only a very small number of people in this House, or indeed the country, who has ever done that. But as has been said, the UK was one of the first to sign up to the ECHR in 1951. Of course, it came into force in 1953, strengthened over the years by protocols. And, of course, the Human Rights Act was a huge step forward in terms of putting those rights on a footing where they could be enforced in the UK's domestic courts. As the honourable gentleman, my honourable friend, the member for Cheltenham, set out, what is actually in it actually reflects, not in totality but in large part, what this Parliament in the past or common law has already reflected in our domestic laws. And I would highlight that my honourable friend, the member for Cheltenham's views are always thoughtful and considered in this respect. So turning to today, Mr. Gapes, how are we doing in relation to those rights we now recognise as forming our human rights framework? Well, let's not judge ourselves, let's see how others judge us, and I think it was the honourable members for Edinburgh East and for Henley who set out, actually, that is a proud track record with the court. Last year, the European Court of Human Rights in Strasbourg considered 354 applications against the UK. That equates to approximately 5.3 applications per million inhabitants, the lowest of all 47 states parties and 1/10 of the European average. Only 21 cases were considered by the court to potentially be of merit and were sent to the UK for a response, with just 2 judgments in cases against this country. And I think that touches on a point alluded to by the honourable gentleman, the member for Strangford, about the need to strike a sensible and appropriate balance in considering these issues in a domestic context, which I think the UK generally does. Of course, after the UK has left the EU, the UK will continue to afford to its citizens access to well-established domestic and international mechanisms to bring their case and obtain appropriate remedies where they... Yeah. Always brave.
I'm grateful to the Honourable gentleman for giving way. I'm pleased to hear he's read the biography of David Maxwell Fyfe. But could I just say, in relation to the commitment going forward, the real concern is that at the moment the Conservative Party position is to remain a signatory for the duration of this Parliament. Can he give a guarantee for the next Parliament and beyond?
If the Shadow Minister is a little bit patient, I will turn to the points which I know a number of members have raised about what our ongoing position is. He may or may not be satisfied, but I will seek to answer him. And as I say, return to that point, individuals will be able to obtain appropriate remedies where they consider their rights have been breached, and this will remain through our common law, the devolution statutes, and of course the HRA 1998. Now, at the beginning of this month, and going to some of the points raised by honourable members, the Shadow Justice Secretary asked my right honourable friend, the Lord Chancellor and Secretary of State for Justice, to give a, and I quote, give a reassurance that the government will not repeal or reform the Human Rights Act in the aftermath of our departure from the European Union. The Lord Chancellor and Secretary of State answered, we certainly have no plans to do so. And I believe that offers a reassurance. As we made clear, maybe not as specific as my shadow would wish, but it offers a reassurance. As we made clear in the Chequers White Paper, and as is clear in the political declaration, the UK is committed to membership of the ECHR and will remain a party to the ECHR after it has left the European Union. And he has set out, the Lord Chancellor has set out, and others, Shadow Minister and others, have set out in this chamber the wording of our manifesto commitments on this matter. Our future relationship, Mr Gapes, with the EU should be underpinned by our shared values of respect for human rights and fundamental freedoms. As reflected in my opening comments, the UK is committed to human rights. Our exit from the EU does not change that or signal a desire to reduce human rights protections. And I would reiterate that most of these actually stem from work by the Council of Europe and the ECHR rather than the EU itself, as the Honourable Member for Henley set out eloquently in his speech. And I would take the opportunity, Mr Gapes, to pay tribute to all those members of this House, including my honourable friend, for the work that many honourable and right honourable members do in serving on the Council of Europe. It is an organisation often not spoken about perhaps as much as it should be, but continues to do quietly and persistently very, very good work. And I have to say, with that in mind, while I recognise the courtesy with which the Honourable Lady for Edmonton put her point, I have to say I simply do not share her view that Brexit will leave a deep hole in the human rights protections in this country. Now, more broadly, and going back to the Honourable Gentleman, the Member for Edinburgh East, I also enjoyed reading Professor Miller's recent report, which he cited, and the work undertaken for the Scottish Government by the First Minister's Advisory Groups on Human Rights Leadership, which has proposed new ways to draw further international commitments that the UK is party to into Scotland's legislative framework, and also in that work, underpinning, I think, the 7 recommendations in the report, Professor Miller did engage in the debate more broadly about human rights in the context of socio-economic considerations and whether those should sit in a revised framework. This is, of course, part of a broader political and philosophical debate with different views, as we've seen in the Chamber today, and I suspect it is a debate that will continue. He asked whether it would continue here. I have no doubt that if it doesn't, I suspect he may well table a debate on exactly that subject. The Shadow Minister, the Honourable and Learned Lady, the Member for Edinburgh South West, asked that I read and consider that report and what is in it. I will do so. I'm happy to read it again and consider carefully. I can't give a commitment as to whether or not I will agree with everything in it, but I will certainly reflect on it carefully, as I do with anything she suggests I should read. UN human rights treaties have not been incorporated into UK domestic law, and they do not require states parties to do so. The UK has instead put in place a combination of policies and legislation to give effect to UN human rights treaties that it has ratified, and we have a long-standing tradition of ensuring rights and liberties are not only protected domestically, but also fulfilling our international human rights obligations, and this aspect should not be neglected. Some honourable members touched on the UN Special Rapporteur's report, I have to say, as has been made clear by other government ministers, while the government will consider carefully the rapporteur's interim findings, the government has made clear it disagrees with the conclusions the rapporteur reaches, and highlighting that compared, for example, with 2010, income inequality has fallen, the number of children in workless households is at a record low, and there are 1 million fewer people in absolute poverty. But I suspect this may well be a debate for another day, which could take at least another hour and a half, if not more. Now, Mr. Gapes, I am the Minister responsible for overseeing the UK's obligations under the UN Convention Against Torture and other cruel, inhuman or degrading treatment or punishments, and its optional protocol, and also the UN Covenants on Economic, Social and Cultural Rights and Civil and Political Rights, not forgetting, of course, the UN Human Rights Peer Review process, the Universal Periodic Review. I take these responsibilities very seriously, Mr. Gapes, and indeed last year went out in person to Geneva to discuss the UK's role in relation to the Convention Against Torture with officials. And more broadly, in my conversation with them, I was clear, as were they, that I believe the UK has a continuing role in leading the way on human rights in the world. To conclude, Mr. Gapes, as the title for this debate was Human Rights in the UK, let me sum up by reflecting that I still believe the UK has a rich tapestry of rights running throughout our history for hundreds of years and reaching out across the globe. They neither began nor will end with the EU, and many of those key rights stem from the Council of Europe. I can understand and entirely appreciate during times of change there will be voices raised, quite rightly, questioning protections, questioning the future and challenging government, and it is absolutely right that that debate takes place. But let us focus on those commitments given, those protections in place, and our historic role, and judge us on those and this country's proud commitment to human rights. Many have suggested that human rights matter, and I, echoing the words of my noble friend the Lord Keane of Ely, would go further. Human rights are central to the way we live now, to the way we wish to live in the future. They are an integral part of the society of which we wish to be a part, and a reflection of our identity as individuals and as a country. Mr. Gapes, and I thank all honourable members who have taken part, and you, sir, for your chairing of this debate, and in particular, though we may not agree on everything, I suspect, can I thank the honourable member for Edinburgh East for this debate. I suspect it will be a subject we return to once again in the future, and quite rightly so.
Thomas Sheppard, to wind up.
Thank you, Mr. Gapes. I'll be very brief. I know we're nearly out of time. I'd like to thank everyone who has participated in the debate. I'm slightly concerned that we didn't have a few more members turning up today, particularly because, unlike many debates in the past in this hall, we don't seem to have that big a distraction in the main house going on at the moment. But maybe as the months go on, we will encourage more of our colleagues to take part. In terms of responding to the debate, just a couple of very quick points. I'll have to check the transcript, of course, but I didn't get from what the Minister said quite the unequivocal and categorical assurances I was seeking in terms of the commitment to the existing Human Rights Act and the protection it affords, nor in particular to what he was requested from several members to give an assurance that there would be no falling behind after Brexit if rights were to improve in other European countries. And I hope that we may get that in the future, but that ambiguity, if for no other reason, ensures that we will be returning to this debate in the months ahead. And finally, if I could just say to my colleague, my Council of Europe colleague, the Honourable Member for Henley, I mean, I would invite him to reconsider his attitude as to whether or not social and economic rights should be accorded the same status as civil and political rights. After all, we have a body of legislation in this country that already gives people the right to education, the right to housing in some circumstances. And I think as time goes on, we will want to incorporate these into the body of what we know as human rights, because after all, it is cold comfort, is it not, to know that you have the right to free expression if you are starving on the streets and haven't got either an income or a home to live in. So I'm sure we will return to this in the months to come. Thank you very much.
The question is that this House has considered human rights in the United Kingdom. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. Order, order.